Hello, and thank you for choosing the Legacy Lawyers as your source of information. We know this might be a difficult time you are going through, but we are here to educate you and help you through the process. Please stay tuned for our question and answer portion.
Good morning, Aaron.
Good morning, David. Ready for your Friday tomorrow?
So ready.
So ready. You have the day off. That's even better.
No.
No?
My time is subject to the requirements of the service, meaning there are things to do. So my weekend leave passes have been revoked.
How sad.
But that's okay. I'm happy to be here.
Well, that's good. Okay, so for this week and the next few weeks, we've been talking about wills and will contests.
Yes.
So within that, how is testamentary capacity determined?
Okay. Essentially, someone is presumed to be competent. Someone is presumed to have the ability to make their decisions. They're presumed to understand their decisions and the consequences of their decisions. So if someone is able to demonstrate that this testamentary decision was made and the person making it, let's see, this person didn't understand the rights, duties, and responsibilities in making the decision, how it would affect them. They weren't able to, in any meaningful manner, understand the risks, consequences, benefits, and essentially all of the different types of abstract ideas of the consequences of their decisions. And if they didn't understand that, then they didn't have the ability to make that decision. I know that's a little vague or maybe too precise. I don't know. So there is a probate code that the court uses, and this is a framework as to how the court sort of steps into the mind of someone using circumstantial and other medical evidence in determining whether someone understood their actions. They use this in conservatorships, they use this in trust contests, they use this in other type of decisions. It's basically how the framework in which the court analyzes someone's mind and comes to a decision. So one factor is alertness and attention. So someone can be so impaired as to not be orientated as to time, place, person, or where they are, or their situational awareness. Someone can have delirium where they're sitting up, but their levels of arousal and consciousness fluctuate so greatly that they fall asleep while they're standing. I've seen that. I've seen that in the will contest. Their ability to attend to a task and concentrate. So you give them a task and their ability to concentrate on the task is so impaired that it is demonstrative of an inability to sort of sit back, think about something, and have an abstract idea as to what the effect of that decision is and do it. Another type of consideration is the person's ability to have rational thought. This is described as information processing, which is the person's ability to process information. Like, these are your children, and I say, okay, well, I understand what my children are and then who they are. So that is demonstrated through impairments in short and long-term memory. If someone has significant impairments in their short or long-term memory, that would affect their ability to know what's going on enough to execute a will, well, then the will may be voided. Ability to communicate with others. Now, just because someone can't communicate verbally doesn't mean that they can't communicate in writing, or vice versa. Or even someone who is asked questions and is able to respond to and in the affirmative and negative to the extent that they can determine that they truly understand their decisions, well, then they have the ability to do it. If they simply are able to communicate and nod to very basic commands, that doesn't rise to the level of having testamentary capacity. Recognition of familiar objects and persons. If this person can't recognize their own children, then that is a significant impairment. Ability to reason abstract concepts, like I said before. in executing a will, it's not good enough for someone to say, "Mama, this is what you wanted," and this just says that everything comes to me, and just sign here. Do you understand? And she nods her head blankly and signs. I mean, that doesn't reflect an ability to understand the abstract concept, which is, the ability to understand, I have this property, I have this family, I want to make this decision, and I know abstractly that in making this decision, this person's property rights are affected and this person's property rights are affected. So everything that goes to this person is something that doesn't go to that person. That's an abstract level of reasoning that is required to have testamentary intent. Ability to reason logically, so that's kind of self-explanatory. Deficits in thought processes, that's something that the court looks at also very significantly in analyzing a will contest. An impairment in the thought process can be demonstrated through hallucination, delusional thinking, severely disorganized thinking, and sort of uncontrollable thoughts and intrusive thoughts. That is a type of impairment that would significantly impact someone's ability to have capacity to execute a will. And the fourth type of sort of mental function is the ability to control or modulate their mood and affect. So someone who is in a persistent state of despair, depression, anger, someone who is completely without emotion, to the extent that their reaction to their environment or to things is very irrational. That is evidence of an inability to modulate their mood and affect, which may speak to an impairment that would deprive them of a capacity to execute a will. So, for instance, if someone is in the hospital, and to the extent that they can't take rational actions or decisions for their own self-interest. So, if someone's in the hospital, if they are not attached to the oxygen or they're not given the acute level of care that they are receiving in the hospital to live, and they just constantly say, well, I just want to get out of here. This is so depressing. Just get me out. Just get me out. I don't care. Just sign me out. That is not someone rationally acting in their own self-interest. Also, if they're in the hospital, it's a terrible situation, a terrible situation in which a rational person would actually have a very significant emotional attitude towards it, and they just have no emotion at all. That's also evidence of a deficiency in that thought process. So one or more or all of these sort of categories of mental functions, if this testator has a significant impairment to one or more of these categories of functions, and as a result, they cannot truly understand the nature and consequences of their action, then they're determined to lack capacity. Isolated incidents aren't good enough. I mean, it has to be something, it has to be evidence that demonstrates that at this time, this person lacked capacity. It could be one or a combination of all those things. And it actually, not only that, but it has to impair their ability as it relates to the decision being made. So someone can make lower level decisions, someone can take one-step commands, like raise your arm, so on and so forth. They have full capacity to take one-step commands. But if their impairments are so that they have a true lack of abstract understanding of that specific decision, and in this case we're talking about a testamentary intent, then they are deemed to lack capacity to execute that document.
Okay.
Okay.
Thank you very much.
You're welcome.
And if you guys have any additional questions, feel free to email us at smm@thelegacylawyers.com. Have a great day.